Well, folks, this is the news we've been waiting all week for. The Commonwealth finally responds to the defense's motion to dismiss counts 1 and 3 of Karen Reed's charges. We got the receipts, and we're going to go through all that and more in today's video. Hello, 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 and welcome to Alexasrewm, where we are not lawyers, we are not medical professionals, we are not law enforcement, we are just people who have opinions about all things going on in the true crime community, including what the heck is going on with the Karen Reed trial. So if you are just stumbling into this news, it's true. The prosecutors opposed Karen Reed's lawyer's motion, of course, as to be expected, to dismiss 2 charges in new filing. So if you're just catching up to speed, remember at the beginning of this week, Karen Reed's defense team asked Judge Beverly Cannoni to dismiss 2 of the 3 charges against their client, including second-degree murder, because remember, in one of my last videos, we learned what the real split was on the second-degree murder charge. It was a unanimous 12-0 not guilty verdict. According to the attorneys, 3 jurors, 1 directly and 2 indirectly, because we had the intermediary and the informant, so 2 affidavits were actually signed by the informant, not directly from the jurors themselves, shared that the jury had actually reached a unanimous not guilty conclusion on the charges. The reported impasse that led Cannoni to declare a mistrial the previous week was just on the OUI manslaughter charge, they said. Later on Wednesday, a 4th juror confirmed the same. Attorney Alan Jackson said in a supplemental filing. Not so fast, prosecutors responded Friday. So this is a little excerpt from it. The defendant's motion is premised upon hearsay, conjecture, and legally inappropriate reliance as to the substance of jury deliberations. Norfolk County District Attorney Michael Morrissey, our big friend, Lally and Friends, right? Michael Morrissey wrote in a filing opposing the motion to dismiss the 2 charges. Further, contrary to the defendant's claims, throughout jury deliberations, the defendant was given a full opportunity to be heard. The jury's communications to the court explicitly indicated an impasse on all charges, and the court carefully considered alternatives before declaring a mistrial. I mean, not really. I mean, yes, the first round when the jury slipped that note saying to Bev, hey, and I'm going to make sure I give full screen on this, that, hey, we are completely deadlocked. We can't come up with a unanimous decision. I do recall, yes, David Yannetti and Alan Jackson did say, hey, we think at this point mistrial is probably the best bet. Lally was the one to argue that. However, the judge decided to give them a couple of more nudges, eventually reading the Tui Rodriguez charge, instruction rather, to motivate them to come up with a decision. The defendant's substantiated but sensational post-trial claim that the jury reached a unanimous decision to acquit lacks any merit or legal foundation. I mean, then get them to testify, bro. Get them on the stand and testify under oath. And if they say, no, this isn't true, this is BS, then fine. Okay, let's go to trial again. But you know that nobody's going to swear to that under oath. After the mistrial was declared, prosecutors immediately said they were planning to retry Reed. A court hearing is scheduled for July 22. So that is where we're at. In the new filing, prosecutors provide a rundown of the jury deliberations and intermittent court proceedings in an attempt to show that Reed's lawyers had ample opportunity to weigh in prior to the mistrial ruling. Jurors first indicated that they were deadlocked in a note to Cannoni, as I mentioned before, on Friday, June 28th. Excuse me. And then again in a subsequent note the following Monday, which caused the judge to read them the Tui Rodriguez instructions, like I just said, urging them to come to a verdict. Later that Monday, the jury sent a third and final note, which led Cannoni to declare the mistrial. The note read, and let's just go over that note. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond reasonable doubt. Conversely, others find the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. Now, in this note, remember, mind you, they don't indicate what specific charges they are talking about. We just assumed all of them, right? The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. Two, because remember, they have to do to a moral certainty as well, not just find her guilty beyond a reasonable doubt, but also to that moral certainty. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. So, let's get into the Commonwealth's response. And remember, there was a lot of confusion about the verdict forms. This was even mentioned the um, in the affidavits that were signed by the jurors, that Alan Jackson had filed in his motion earlier this week too, as well as David Yanetti's. There was confusion. They were confused as to why, especially with the last one that came forward, the fourth one, about Judge Cannoni never asking them about the verdict or what they had actually decided. So it seems like the instructions weren't as clear as maybe she had thought they were, because she seemed pretty adamant about, well, it just seems like if you don't think that they're guilty, then just don't check the box. And I can understand why some people wouldn't, maybe in their brain, they wouldn't read the form like that. So it is important to be explicitly, just annoyingly precise and clear with your instructions to avoid this kind of confusion. Make sure that the jury understands, get that verbal confirmation from them as well too. So this is what the Commonwealth's opposition to defendant's post-trial motion to dismiss says. I have not read a single word of this, so we're going to react to this in live time, try to make sense. I was just recording a video for the Baldwin updates, and that was a shitstorm in itself. So that took up the majority of my day, but I wanted to make sure I got a video out on this to you guys as well too, because this is really important news with the hearing coming up in 10 days, 10 days from now of when I'm recording this. So let's dive in. Now comes the Commonwealth in opposition to the defendant's post-trial motion to dismiss her indictments for second-degree murder and leaving the scene after causing death. So those are the two charges that they're looking to dismiss. As the defendant's motion is premised upon hearsay, conjecture, and legally inappropriate reliance as to the substances of jury deliberations. Further, contrary to the defendant's claims, throughout jury deliberations, the defendant was given a full opportunity to be heard. I mean, were they? They weren't necessarily asked, like, hey, do you oppose to this? Like, what do you guys think? Whereas, like any other note, there was an open forum for conversation before they proceeded ahead. And even the decision to give the Tui Rodriguez instruction started with a conversation between the judge and the attorney. So I mm, I don't know if I agree with that 100%. The jury's communications to the court explicitly indicated an impasse on all charges. No, they didn't. No, 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 they didn't. And let me pull up that article one more time with that note. I just X'd out of it. So hold on one second, guys. So here is again the note that was read. Despite our rigorous efforts, we continue to find ourselves at an impasse. That's what they say. They don't say that they're at an impasse of all charges, as Morrissey claims. So, no, sir, you are wrong. It's not clear what they're on an impasse on because nobody asked them. And the court carefully considered alternatives before declaring a mistrial. Not necessarily. Bev was kind of like, okay, I'm not going to make you do that. I'm declaring a mistrial. Case closed. The defendants substantiated but sensational post-trial claim that the jury reached a unanimous decision to acquit lacks any merit or legal foundation. Why? Because people are breathing down your neck, bro. On June 9th, 2022, the defendant was indicted by a Norfolk grand jury for second-degree murder in violation of this GLC 265, etc., manslaughter while operating under the influence in violation of yada yada yada, and leaving the scene of personal injury, death in violation. On April 16th, 2024, a 10-week jury trial commenced. The jury began their deliberation on June 25, 2024. In addition to the 3 indictments, the jury was instructed to consider 2 lesser included offenses to manslaughter while operating under the influence, involuntary manslaughter, motor vehicle homicide, OUI liquor, and negligence in violation of yada yada yada. The defendant's motion states that the court's decision to declare a mistrial was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Yet, the defendant's motion and supporting affidavits of counsel inexplicably omit the full opportunity that the defendant was given to be heard and the defendant's consent to the mistrial. I mean, again, not necessarily. Everything just seemed very like rush, 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 rush. Let's get out of here. Let's go home. Let's hit the beach, right? Beginning on Friday, June 28th, 2024, at approximately 12:15 p.m., the jury sent a note stating, "I am writing to inform you on behalf of the jury that despite our exhaustive review," so I believe this was the first note, "of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict." At the time, the court requested argument from the Commonwealth. So again, you're kind of like contradicting yourself here because on one hand, and the other hand, that's a quote from Deadwood, from Deadwood. On one hand, you're saying, well, at this point, the judge invited the attorneys for arguments on what we should do, but that's not what the case was in regards to after the jury came back that final time with that last note. That's not at all what went down. So you're kind of contradicting yourself in a little bit of a way, in my opinion. Bu- 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 bum. Requested argument from the Commonwealth and defendant as to whether the jury had engaged in due and thorough deliberation. So wouldn't Judge Canoni present the same requested argument, the same opportunity from the attorneys? The Commonwealth responded that the jury had not had sufficient time to deliberate and requested that the jury be instructed to continue their deliberations. That's true. Larry did request that, and the defense didn't. Attorney Yannetti argued, "We believe that there has been sufficient time," and advocated for the jury to be declared deadlocked and provided the Tui Rodriguez instruction. Attorney Iannetti stated, "The word exhaustive is the word that I think is operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they are at an impasse. You know, this is a case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report they were not allowed to get because it didn't exist. And I think the message has been received that the evidence is closed and they won't be getting anything more." Right, exactly. Because if they're hung up on this one thing and this one thing only, then like they're just going to continue spiraling in this circle of arguing. And that's not fun for anybody, especially when you're like stuck in the same room with the same people you've been seeing for 10 weeks and you're just hot and sweaty and hungry. And all you want to do is just go home, take a freaking shower, and eat a freaking burger. Maybe that's just me. They've been working essentially nonstop over the last 3 to 4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the Tui Rodriguez model instruction and go from there. And exactly, that's what he said. And again, that instruction is just it's kind of like that one last little pep talk from, Coach Taylor, Friday Night Lights, like, "Come on, guys, you can do this. We got this," right? I forget what that team was. The court ruled that given the length of the trial, number of exhibits, and complex issues in the case, there had not been due and thorough deliberations and instructed the jury to continue deliberating. Yep. On Monday, July 1, 2024, at approximately 10:45 a.m., the jury sent another note to the court stating, Judge Canoni, despite her commitment to the duty entrusted in us, we find ourselves deeply divided by the fundamental differences in our opinions and state of mind, excuse me. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implication it holds. So they're pretty much saying like our own personal biases are the things that are conflicting. And I did see a tweet go out earlier from Turtleboy confirming that he does know the identity of the fifth juror. That was a guilty verdict, not on, of course, the second degree murder or the count 3 charge of leaving the scene of personal injury or death, but on the murder, on the involuntary manslaughter 2 charge. So yeah, I mean, I can definitely understand that. And if that is true, and I tend to believe when, Turtle Boy does his due diligence of really vetting sources, that this this fifth juror that would have voted guilty was I believe, former law enforcement, as well as now he works in the medical field. So, which is interesting. Very interesting, but it makes sense. Ex law enforcement, yeah, I could see you being swayed that way. Following a receipt of that note, the court again inquired of the Commonwealth and defendant as to whether there had been due and thorough deliberations. The Commonwealth argued that although the jury had been deliberating for approximately 22 hours, given the length of the trial and number of witnesses, the jury had yet to engage in thorough deliberations. Attorney Yannetti again sought a Tui Rodriguez instruction, stating that the jury has come back twice, indicating essentially that they're hopelessly deadlocked. They said they've been over all the evidence, and at this time, they say they have fundamental disagreements about what the evidence means. I mean, yeah, especially when you're telling them this is all the evidence that you can't request testimony, um, readbacks or anything like that. They can't, whatever their notes say could be, I mean, depending on who you are and the kind of note taker you are, the way that you're processing information and the way that things are moving so quickly in court, you could easily lose or potentially manipulate unconsciously what you're actually writing and what you're trying to recall from all the freaking witness testimony in this case. So I can understand getting mixed up, getting confused, and then just kind of defaulting to the highlight reel of what you can or cannot remember. The court found at this point the jury had engaged in due and thorough deliberations, noting this has been an extraordinary jury. The court indicated it had never seen a note like this, reporting to be at an impasse. At approximately 11 a.m. on July 1, the jury was advised of the full Tui Rodriguez instruction, including that it was the jury's duty to decide this case if you can do so conscientiously, that there is no reason to believe another jury would be more competent to decide this case. On July 1 at approximately 2:30 p.m., the jury sent a final note to the court. It was pretty quick, I remember, too. After they got this instruction, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. So, again, this is more of the note we read. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, but again, why didn't you ask them? Why didn't you ask them? Is this of all charges? It's such a simple freaking question. Why wasn't it asked? Others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only to serve to force us to compromise these deeply held beliefs, which is fair. You can tell that they all respected each other's opinions. That sounds like a really great jury. Um, to have on a case like this, honestly. Following receipt of that note, the court discharged the jury and declared a mistrial. So then what happened after that, Morrissey? What happened after that? The representations made in counts. So now he just goes right to what they said in the affidavits. Like, he isn't even notice how the whole time too he's like laying out, this is what happened. This is what the judge read. The judge requested arguments from the attorneys. But not here. Not here. The court discharge, she reads the note, she gets the note, she discharges the jury and declares a mistrial. But she doesn't open up the opportunity for the defense or the Commonwealth to make any kind of argument. And I'm not a lawyer, right? That's why I say that at the beginning of every video. I'm not a lawyer, but I feel like wouldn't based on the previous series of events, wouldn't that be the logical next step? Is you get this note, this has been the whole process for you the whole time. You get the note, you tell the attorneys, "Hey, this is the note we got. What do you got to say about it?" Cool. Now let's bring the jury in. But instead, she reads the note, she brings them in. Everything's moving fast. You don't even know what to think at that point. You don't have a time to really wrap your head around what's going on. And then the jury's there. And then you're dismissing them and then you're declaring a mistrial. So wild. The representations made in counsel's affidavits have no legal bearing on the mistrial as the jury did not reach any verdict, partial or otherwise. But Morrissey, that's not necessarily true. Do you have that in writing? Did they say it in their note that they couldn't come to a decision for all counts, for all charges? No, there was nothing that indicated in any of those notes that they were specifically at an impasse for everything. It was not asked, it was not on the record. So no. Incorrect, sir. Incorrect. The only verdict which can be received and regarded as a complete and valid verdict of a jury upon which so it looks like he's reading case law, upon which a judgment can be rendered in an open and public verdict given in and assented to an open court as the unanimous act of the jury and affirmed and entered of record in the presence and under the sanction of the court. The verdict which determines the rights of the parties and is admitted of record and upon which judgment is rendered is the verdict received from the lips of the foreman in open court. It is not enough to show that the jury may have agreed on some issues at some time if that limited showing were to control uncertainties would be invited. So I feel like they'd be singing a totally different song if the tables were turned, right? If they were like, no, we actually did vote guilty. You know that Morrissey'd be having a freaking field day with this thing, right? Like, we gotta go to trial now. Gotta go. We gotta lock up Karen Reed right now. No error in the judge's refusal to accept the not guilty verdict slips, found in jury deliberation room after the jury was discharged, where the slips were in contradiction of the jury's report to the judge in open court that they were deadlocked. So I guess he's claiming, I don't know if this is according to case law. It kind of looks like it is. But it seems like he's saying that we didn't find any not guilty verdict slips found in the deliberation room, but even still, Bev said if you think she's not guilty, then they would think to not check anything. So no, it's like that's in complete contradiction with what Bev was saying about the whole verdict slip form argument. The hearsay comments and jury statements about what happened are legally irrelevant as the jury failed to reach any verdicts. In Bluford, the jury sent a note to the court indicating they were hopelessly deadlocked, and the court asked the foreperson to disclose the jury's votes on the 3 charges: first-degree murder, manslaughter, and negligent homicide. Foreperson reported the jury unanimously agreed the defendant was not guilty of murder, but were deadlocked on manslaughter and had not voted on negligent homicide. Court gave the jury an Allen instruction, akin to the Tui Rodriguez instruction, that emphasized the importance of reaching a verdict and instructed the jury to continue deliberations. I mean, like, again, after a half hour, the jury reported that they had not reached a verdict and mistrial was declared, but none of this happened. The court didn't ask the foreperson. So, like, what are you talking about? The United States Supreme Court rebuffed the defendant's claim that the jury acquitted him of murder, as the foreperson's report was not a final verdict, because the jury had continued to deliberate and, more importantly, gave no indication that they were still unanimous on the murder charge. The United States Supreme Court emphasized that when jurors engage in discussions about the circumstances of the crime, it often causes one to rethink their stance on a greater offense and revisit a prior vote. The very object of the jury system, after all, is to secure anonymity by a comparison of views and by arguments among the jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. Tui Rodriguez instruction is designed to urge the jury to reach a verdict by giving more serious consideration to opposing points of view. It must be recognized as a practical matter that the jury votes on included offenses may be the result of a temporary compromise in an effort to reach unanimity. A jury should not be precluded from reconsidering a previous vote on any issue, and the weight of final education should not be given to any jury action that is not returned in a final verdict. Oral affirmation of guilt or acquittal in open court is the only evidence the court can receive of the free and unanimous assent of the jury to the verdict. See, freaking 15 pages long. You don't see any of these. Even the motion to dismiss was shorter than this, Morrissey. Come on now. The jurors' notes were unambiguous. Wow, I can't speak today. Unambiguous that the jurors were deeply divided by fundamental differences in our opinions and state of mind that resulted a starkly divided jury as to the charges. Emphasis on plural. The jury consistently indicated that their impasse was not due to a lack of understanding of the law or the charges. What? Really? But a profound, divergent, and deeply held convictions, ultimately leading to a point where consensus is unattainable. The jury's notes did not indicate agreement or acquittal of any charges. Rather, it was evident that the jury was unable to agree on any charges due to the sincere adherence to their individual principles and moral convictions. I mean, yeah, you already said that, bro. Contrary to representations made in the defendant's motion supporting affidavits, the defendant advocated for and consented to a mistrial. Was there verbal consent on the record? I didn't hear it. As she had adequate opportunities to object and instead remained silent, which removes any double jeopardy bar to retrial. I mean, why would Karen Reed speak out for herself about the mistrial? She has attorneys to speak for her. That's why they're there. Consent to a mistrial may be inferred from silence where a defendant had the opportunity to object and failed to do so. But I mean, again, like, why would she be like, I object? Like her attorneys would speak on her behalf. That's why they're there. Where defense counsel told judge he believed jury was at an impasse in deliberations, so he's pretty much requoting Yannetti had no objection to judge declaring mistrial, and such consent removed any double jeopardy bar to retrial. Despite having an adequate opportunity to object, defense counsel remained silent. Proper to infer from counsel's conduct that defendant consented to the mistrial. The manifest necessity test had no application in situations, whereas here the defendant requested or effectively consented to the mistrial. During her full opportunities to be heard on June 28 and July 1, at no time did any of the defendant's three counsels request inquiry as to what charge or charges the jury was deadlocked on. Rather, the defendant was quick to request a Tui Rodriguez instruction at first opportunity, indicating a belief based on the clear and obvious language of the jury's notes that, as stated by Attorney Yannetti, the jury was hopelessly deadlocked and had exhausted all manner of compromise and was engaged in fundamental disagreements of what the evidence means. It's a matter of opinion, it's not a matter of understanding. Counsel's request for Tui Rodriguez instruction permits the inference that both parties were provided an opportunity to be heard on possible alternatives to a mistrial. The timing of a Tui Rodriguez charge is committed to the discretion of the trial judge. Once a Tui instruction is given, and jury could not be sent out again to continue deliberations without that consent. Yep, we know that. Furthermore, following the discharge of the jury, the court engaged the Commonwealth and defendant in discussion about choosing a status date for scheduling a retrial. No time during that hearing did the defendant object or indicate displeasure with the mistrial. The mistrial was also supported by a manifest necessity jury deadlock. In considering whether to declare a mistrial over a defendant's objection, the court must give counsel a full opportunity to be heard and careful consideration to alternatives to a mistrial. But, like, again, over a defendant's objection. But I mean, like, why? I just feel like with the cadence of how Bev was running her show, there would be, like, she would have prompted the attorneys, right? She would have said, hey, counsel, do you have anything to say? I mean, I don't know. What do you guys think? Do you think that Alan Jackson and Yannetti should have spoken up, or do you think that they were equally as confused as the jury was? Um, a frequent and traditional example of manifest necessity to declare a mistrial is where the jury were discharged because they were unable to come to an agreement on a verdict. Mistrial warranted where jury reported inability to reach decision after 4.5 hours of deliberation, during which jury twice sent judge messages about an impasse and judge inquired about jury's ability to reach. So he's just quoting a whole lot of case law here, describing a hung jury as prototypical example of manifest necessity. Mistrial warranted where jury reported deadlock on fourth day of deliberations after judge inquired about ability to reach verdict. The trial judge, is best situated to determine whether the ends of substantial justice cannot be attained without discontinuing the trial. In declaring a mistrial premised upon the trial judge beliefs that the jury is unable to reach a verdict, that decision is treated with great deference, because otherwise there would be a danger that the judge would employ coercive means to break the apparent deadlock. Deadlocked juries are particularly susceptible to coercion, so they're alleging that Alan Jackson and David Yannetti put them up to it. Am I reading that right? The term manifest necessity is another or coercion. I don't know. Or like coercion by other jury members, like post trial. The term manifest necessity is another way of saying that in a particular case, the right of the defendant must yield to that of the public. Trial judge interacts directly with jurors and is in best position to determine whether jury is deadlocked. The court, we only have 5 more pages, guys. We're getting through this. The court engaged, again, just to say, like, do you notice the difference between Morrissey and how the defense files their motion? How just, like, easy of a read, gets right to the point. Yes, they quote some case law, but, like, I just feel like it gives me vibes that Morrissey's, like, in love with how he writes. Like, he just loves, if he's not speaking, he just loves the way that he can put together a filing. I don't know, that's just me. I feel like he's that kind of person that loves the way, like, he sounds when he speaks. I don't know. The court engaged in considerable efforts and sent the jury back to deliberate 2 times following I mean, yeah, like, dude, you said, like, you're just, like, repeating the same freaking thing over and over again. And in addition to finding that the jury had not engaged in due and thorough deliberations and providing the Tui Rodriguez instruction at the request of the defendant and to her satisfaction during deliberations, the court amended the verdict slips to depict clearly the lesser included. So they're like, oh well, we even like did like what you guys wanted. Like we shouldn't have had to. It should have been clear. Um, because you wanted to your satisfaction. Like, no, it was confusing AF, and it was still confusing. It was still confusing, especially because you essentially said, like, listen to my instructions. Not that you can read and follow them along, but make sure you're listening and pay attention to what I'm saying in this long ass instruction read. I think that took like an hour or something ridiculous like that for Bev to get through. Like, nobody's got time for that. Like, why? Like, what about like a when you're taking a test, like a state exam or something in like high school, like why can't you give us like a little prompt or blurb and say, "Hey, by the way, in case you were falling asleep while I was reading this freaking long ass thing, here's a summary of how you need to interpret the form, what it means." Then maybe have I don't know, whoever's in charge, the clerk who's in charge of kind of like babysitting the jurors, like say, "Hey, do you understand?" Maybe go one by one. "Hey, do you understand those instructions? Do you understand them to a certainty, down to a T?" Cool, awesome. Next juror, boom. Like, I don't know, there just needs to be something like that so that stuff like this doesn't happen again. I don't know if that happens anywhere, but that would just make the most sense to me and avoid all of these problems. Is just getting verbal confirmation, or even better, signed confirmation, verbal and signed confirmation that yes, you understand exactly how to deliberate and how to fill out this form. Like, I just don't understand. Why are you just leaving it up to these people and who were exhausted after listening to weeks and weeks and weeks and being separated from loved ones of just a ridiculous testimony, being overly exhausted, overworked, underpaid because jurors don't get paid a lot at all to, for their duties. So like, and God knows what kind of food they're even feeding them. Oh my God, I can't even imagine. Probably Chick-fil-A every day, right? Or somebody said D&E pizza too. Um, has never required a trial court before declaring a mistrial because of a hung jury to consider any particular means of bringing the impasse, let alone to consider giving the jury new options for a verdict. The defendant's claim that the judge should have inquired of the jury holds no merit. I could just hear him saying it's no merit, as nothing in our case law or in required the judge to make either inquiry whether there was reasonable probability or any unanimous verdicts, or if the jury would consent to further deliberations. It's gotta stop. I can't. I can't. As a matter of course, and the circumstances before the judge did not necessitate either inquiry. The final note from the foreperson unequivocally stated that the jury were unable to come to a unanimous decision. In other words, that the jury were deadlocked. Yeah, we get it. But deadlocked on what? It wasn't clear. It wasn't. The note did not suggest, for example, that the jury was merely having trouble in making decisions or needed further instructions from the judge. Given the 4 days of deliberations, I mean, maybe they didn't know how to express that too. Like, again, what went down in that conversation, in that post trial? Like, after declaring the mistrial, when Bev went down to talk to them, what exchanges went down? Can she be called as a witness? I mean, we just saw the frickin' unbelievable Carrie Morrissey testifying in the Alec Baldwin trial. Who would have thought that's how things would have turned around? I didn't. So anything, let's get Bev on the stand, testifying under oath. Was there a clerk around? Was there another witness around to testify to what went down, the conversation that was had? I would love to have been a fly on the wall. Um, Given the 4 days of deliberations, the jury's indication that they had carefully reviewed all the evidence and that their divergent opinions were premised upon deeply held moral convictions, the court was left with no reasonable alternative other than to declare a mistrial. Like, you've said this like pages and pages ago, bro. The court was left with no reasonable alternative other than to declare a mistrial. Further consultation with counsel would not have produced any fruitful alternatives, nor, well, how do you know? How do you know? Nor was there a reasonable probability the jury would have consented to deliberate further, particularly when the jury wrote to continue to deliberate with futile and only served to force us to compromise these deeply held beliefs. And a lot of people brought this up too. If you have been following the Baldwin case, I just dropped that last video yesterday at the time I'm recording this today. Um, but commenting that, like, just imagine if this case was, if the judge on this case was Judge Summer. Like, I think things would be different. I think she'd look at this and be like, What the F, Morrissey? What the F are you even talking about?" Like, even after all of that, like, that just clown show of Morrissey being on the stand, Carrie Morrissey in the Baldwin trial, she still prompted the attorneys and asked, "Do you want to allot for, like, 15 minutes each on this hearing before we, like, get to my ruling? Even though you know what's coming, do you want an opportunity to argue?" Even then, she prompted that, and I know it's a different state, it's a different jurisdiction, not everything is it goes the same from county or from state to state, I understand that, but I feel like just proper court etiquette, like, that just makes sense to me, is that if you're gonna run your show a certain way, people are expected, like, "Okay, you're gonna prompt us and ask." Well, like, we don't know, it's your courtroom. Moreover, whether counsel initiates contact with the discharged juror. Okay, so now they're getting into post-trial, post uh, Judge Bev declaring a mistrial, juries go home. I think a day later, it was a day later, the first juror comes forward, that's juror A, that direct affidavit signed by that actual juror themselves, not an informant or intermediary party. Moreover, whether counsel initiates contact with the discharged juror by first sending notice to the opposing party with the substance of proposed communication, or if the juror initiates contact with counsel as alleged in the defendant's motion, counsel may communicate with jurors only about permissible subjects. Permissible subjects include counsel's performance during the trial, extraneous influence on the jury's deliberation, or a juror's bias towards a defendant. But again, would this have been a totally different story if this was ruling in the Commonwealth's favor? They don't like that. Neither extraneous influence nor a claim of juror bias is alleged by the defendant to have been an issue. Even in circumstances where jury testimony is needed to ascertain whether there was a racial or ethnic bias or extrajudicial influence, a judge may not inquire into the juror's subjective thought processes, con- uh, con- content of deliberations, or reasons for concluding guilt or acquittal. Rather, what the defendant's motion is entirely premised upon, and what is expressly prohibited inquiry, is that of the jury's deliberative process and the substance of the jury's deliberation. And I actually, we actually pulled this up in one of my last videos too, of like what the exact rules are. Like, can the defense interact with a jury post trial? Because I know too, like in the Adelson case, there was a juror that, I think, an alternate. So I know it's a little different, but an alternate came forward to the defense team, Charlie Adelson's defense lawyer, Dan Rashbaum, that they would have been a guilty verdict, or not guilty, excuse me, not guilty verdict. So I know that's Florida, different state, different rules, but according from what we read, I mean, it didn't seem like anything was necessarily done wrong. on the defense's part. And again, if you're so worried, and get them to testify. If you feel like you're worried, you're sweating, you don't want them to testify. That's why you're trying to nip this in the bud. If you weren't afraid, you'd be like, all right, put them on the stand. Let's do this thing, right? The secrecy of jury deliberations has served as a bedrock of our judicial system. Here he goes again. And the inquiry into the jury's deliberative processes when intrude improperly into the jury's function. A common law principle that is essential to the freedom and independence of jury deliberations that their discussions in the jury room should be kept secret, inviolable, excuse me, was not, and arguably could not be overruled by Rule X, Y, and Z. Internal citations quoted and omitted, blah, blah, blah. It is improper for counsel to inquire with jurors or through intermediaries. According to what? The individual or collective thought processes of the jury, the reasons for their decision, or the substances of their deliberation. Massachusetts continues to adhere to common law principles, barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry. Well, where's your case law for that? Like, you got rule here, but where's your case law for that one? Similarly, it would be improper for the court to inquire through affidavits or an evidentiary. Oh, so they don't even want it. They're like, even through a hearing, we can't do it. It'd just be improper. Why? Why? The substance of the jury's deliberations. If after communicating with the juror, an attorney wishes to secure an affidavit from the juror, any such affidavit must focus on extraneous influences, not on the substance of the jury's deliberations or the individual or collective thought processes of the juror or the jury as a whole. Trial judge acted within discretion to declare mistrial where proposed, inquiry of deliberating jury could not be made without inquiring into the deliberative processes of the jury. The Supreme Judicial Court has instructed that whenever a judge asks individual jurors about the possibility of extraneous influence. So pretty much, like, did you watch the media? Did the media change your mind? Because people have seen the outlandish of what 10 to or like I saw like 8 to 10, which didn't make sense at all. 10 to 2, all these bizarre speculations of what the false speculations of what the actual jury split was. And that's the reason why they came forward. I mean, it's plausible that, yeah, they probably did see that and they were like, what the F? This isn't what went down at all. And I want to clear my name because, not for nothing, even though I'm anonymous to the world, I wasn't filmed. People still saw my face. The media knows who I am. The defendant knows who I am. Brian Albert knows who I am because he's staring me freaking down from across the room. And I don't want to put an innocent woman away if I don't believe that she should be retried for something that we all agreed to unanimously. Sounds like pretty stand-up people to me. The purpose of the individual voir dire is not to delve into jury deliberations. There should not be an inquiry into a juror's individual or the jury's collective thought processes. Likewise, polling the jury on the various possible verdicts during their deliberations or after their discharge would constitute an unwarranted and unwise intrusion into the province of the jury. And the Supreme Judicial Court has cautioned strongly against the risk of coercion inherent in questioning jurors, particularly in individual colloquies. One cannot assume from the mere report of a deadlock that there is any final verdict lurking within the deadlock that may be extracted. In many instances, asking a deadlocked jury about partial verdicts would constitute attempting to extract from the jury something that does not exist. I mean, I don't really agree with that. Asking a jury to report where they stand on the offense as charged invites a report that may be based on only preliminary tentative deliberation, what if any, on that level of offense, or hasty resumption of deliberations concerning that level of offense in an effort to satisfy the judge's apparent desire for a decision. Such inquiries of the judge may succeed in extracting a partial verdict, but we could not have confidence that the partial verdict was the product of a thoughtful and thorough deliberation process. The risks of juror coercion are too high, and the reliability of any such partial verdict returned is too low to warrant such an approach to salvaging some partial result from a deadlocked jury. Similarly, even if the deadlock does pertain to some distinction between the various levels of an offense, a judge has no way of knowing whether the jury has, in fact, fully considered the offense as charged. A desire to extract information from a deadlocked jury does not solve the significant problems in attempting to do so at court's inquiry into possible verdicts and properly intrudes on the jury's function and the ostensible, yikes, sorry guys. Oh my god, we're at the end. I cannot believe we're at the freaking end. Benefits to be gained by such a procedure are outweighed by its risks. For the foregoing reasons, the defendant's motion should be denied, as there was no verdicts that acquit the defendant, no grounds for the court or counsel to inquire into the deliberative process of a discharged jury. The defendant consented to the mistrial, and the court properly declared a mistrial due to a deadlocked jury who was at an impasse due to their starkly divided perspectives on the evidence and their sincere adherences individual principle and moral convictions. As such, retrial is not barred by double jeopardy or constitutional principles, and the Commonwealth may retry the defendant on the three indictments and any appropriate lesser included offenses respectfully submitted for the Commonwealth. Michael W. Morrissey, who is now in office, and Laura McLaughlin. Okay, so not Lally. Lally didn't sign this. I don't know if that means anything, but there you have it, kids. So I'll link this in the description below if you want to take a read through it again. I know that was kind of painful because it was a lot of repetition. From Michael Morrissey. But what do you think this means then for the defense? Is Bev going to respond to this? When is she going to respond to this? We will be keeping a close eye on all of this news and more. I know a lot of people are covering this as well too. There's been a lot of great legal perspectives, so I encourage you as always to check them out as well too. But that, I mean, I can't say I'm surprised, honestly. I can't say that it wouldn't make sense for them to it wouldn't not make sense for them to oppose this motion. Of course, they want to retry her, they want to get her, they don't want to have to admit that they've effed up. They don't want to be caught in the same situation. Hello, like the Baldwin trial, right? Except in that case, well, we won't even get into that. I have a video on that, but I'm just curious to see if the judge comes to a decision, if Canoni does the right thing and allows an evidentiary hearing with the jurors and calls them up one by one, maybe even keep them separate from each other. Call them in one by one, not in front of their peers, so there's no pressure. And just say, hey, what did you originally vote? Why would they lie under oath? Why would they purposely perjure themselves on the stand? Put them on the stand. They're not going to lie. They're not going to lie. What did they have to gain by lying? They lie, they get caught, they get perjured, they get tossed in the can. Nobody wants that for something like this. Absolutely not. That's why these people are coming forward. And before I let you guys go too, I know I mentioned there is the possibility of a fifth juror coming forward, not with the not guilty verdict, but confirming that the not guilty verdicts were in fact correct according to the other four jurors that we have heard from so far. So this report comes in from Turtleboy, so I'm going to bring it up right now. Okay, so this is what Turtleboy tweeted earlier today. Breaking, I can confirm that the foreman is not one of the four jurors. So interesting. Who has reportedly said that the count of murder was 12-0. He is the fifth and the first to be on the record as saying he believed Reed is guilty of manslaughter. Okay, so that's interesting news. We can now report with confidence that the foreman of the Karen Reed jury is a former police officer and current physician's assistant for surgeons in a Boston hospital. Very interesting. Very interesting. I know, some people have said, like, "Oh, was the jury pool tainted?" Um, I don't know. We can only speculate, like, did the McAlberts pay some of these jurors off? To get a few in? I mean, at the end of the day, both sides, both teams had to decide, unanimously, right, on their jury pool, so I don't think that that's necessarily the case, but you never know. I'm not going to really entertain that speculation too much, but let me know what you think in the comment section. So colleagues of his had reached out and said that he was stuck on pieces of taillight embedded in John O'Keefe's shirt. And this is the thing that I was thinking. I'm like, okay, they were asking about the cert report. They were asking about the taillight pieces. That is what they were hung up on. And I guess even working as not only a former police officer, though I can instantly see your bias, as a somebody who works in a hospital and works with surgeons, like, you would think, like, you have to have some level of knowledge of science, right? I mean, even if you're not a science person like me, like, science was my least favorite subject, and I could understand that Trooper Paul's entire testimony made absolutely no sense, and anything that the ARCA guys were saying, the Crash Daddy said, I was like, "Yeah, that makes so much sense," and, like, the way you're explaining it, it just logically, yeah, it scientifically doesn't make sense. So this is interesting, the pieces of taillight embedded in his shirt, but then it's like, I can see it getting heated and people saying, "Well, then why wasn't there his DNA found in the inside of the broken taillight, right? Why was it only embedded in his shirt? Why weren't there any pieces embedded into his skin, right?" This medical professional apparently ignored the lack of bruising or other injuries below the neck. I mean, that for me is a huge thing too. I mean, I've always said, like, the biggest thing for me is the fact that one, I mean, it's just ridiculous that John O'Keefe was hit by a vehicle, let alone Karen Reed's vehicle. There's no evidence to support that claim. Not one shred of evidence in my mind. The lack of injuries below his, like, it makes no freaking sense, but also too, the fact that Karen Reed was physically not there to do it in the time frame that they said she did it. So, like, that alone for me, I'm like, she wasn't there, she couldn't have done it, period, end of story. You wanna say he was hit by a car, well, maybe it wasn't her car who hit him, but even still, scientifically, those injuries most likely were not sustained from him being struck by a vehicle. And ignored the testimony exactly of the two ARCA experts who said John's injuries were inconsistent with a vehicle collision. Yeah, exactly. Period. End of story. In other words, planting microscopic taillight fragments in a search. I mean, it feels like they crushed up the taillight in like a freaking blender and just like sprinkled it in, right? In a search a year later successfully kept the jury hung on count two. It is notable that the foreman is telling the same story, murder two, off the table. So every five jurors, even the guy who's like, yeah, I thought she was guilty of the second one, but no, first and third, we were like, no, that's no way. Even though it really doesn't make sense to me. But again, that's why I think we want to see them testify or want to hear that they testify to that. on record, under oath. The jury was only hung on manslaughter. None of them believe Karen Reed intentionally hit him with her car and left him to die in the cold. So, yeah, she's not this cold-blooded killer. And I think if you really want to nip this thing in the bud, Morrissey, you get them to testify under oath. But you're afraid. You're afraid because you know that the defense is telling the truth. And they came back and they got the receipts. Oh boy, they got the receipts. And we are going to be waiting for those receipts to come out and this continue to unfold. So if you like today's video and you want to stay up to date with the latest and greatest Karen Reed news, please make sure you hit the subscribe button. Make sure you hit the notification bell so you don't miss another update from me. Make sure you hit the like button. It's free. It doesn't cost you anything to do, and it helps tell the YouTube algorithm that this is newsworthy news. It's important news. Remember, we have to continue to put pressure on the DA's office. We have to continue to put pressure on the state of Massachusetts, and heck, even Governor Healy too. What are you doing, girl, with your buddy Morrissey? Come on now. We got to continue to put pressure on these agencies to do the right thing. But if you want to make a donation and support this channel, we now have a couple of options. You can click the Cash App option if you prefer. You could do it through Stripe. You could buy me a coffee, whatever you're feeling. Whatever you're feeling in that day, all donations are welcomed. And at the end of every video, if you leave me a note, I will read your note to the interwebs people, to this community on this video. I will include your name in the credits section as well too, as my way of saying thank you so much for supporting my growth as a small content creator. Without you guys, without your support, this channel would not be. And I think, again, these stories are really important to share. And this is just a deep, deep passion of mine. And I couldn't be more grateful to have you all part of my community. And when you make a donation, at the end of every day, I'll tally up those donations and donate 20% directly into the Karen Reed Defense Fund. I'll put a receipt, post it onto the community tab so you can all see. If you want to follow me on Twitter, you can do that too. But like I said, if you can't make a donation, no worries. Just hit that like button. That also helps me out a ton, more than you can imagine. So thank you so much for watching, and I will see you all in the next one with some Turtleboy updates as well.